the High Court today has issued conservatory orders suspending the implementation of the Adani-Ketraco energy deal. In her ruling, Justice Bahati Mwamuye directed that all projects under the partnership between the Ministry of Energy and the Adani Group will remain on hold until a pending case challenging the deal is heard and determined. The conservatory orders were issued in response to concerns over the transparency and accountability in the Adani-Ketraco deal, which involves the development of high-stakes power infrastructure such as transmission lines and substations. The case challenging the deal alleges that crucial details on the agreement's term and potential impacts may not have been sufficiently scrutinized. Critics argue that this partnership could have far-reaching effects on Kenya's energy sector, potentially increasing costs and raising concerns over the privatization of essential national assets. The ruling restrains the Ministry of Energy from entering the new agreement with Adani or advancing existing ones related to transmission lines, substations, and other power infrastructure developments. In other news, a three-judge bench today declined to recuse themselves from the case to remove Gachagua from office, insisting that they acted fairly toward all parties without favoring either side. Both parties have 5 days to submit an amended petition before the case officially resumes on October 29th this year.
So paragraph 95 is what the court says. Accordingly,
impeached Deputy President Rigathi Gachagua has been caught in shock after a three-judge bench refused to recuse themselves in Gachagua impeachment case, just after the lawyers representing his experienced doubts about the three-judged panel appointed to oversee the case, claiming there is a conflict of interest. Justice Eric Ogola stated that they based their judgment on 4 grounds: the concept of recusal in line with the Constitution, impartiality as a ground for recusal, whether the application met the required threshold for bias, hence according to the judges, the application did not meet the set criteria and hence was disallowed.
The need for expedition coupled with the urge to balance the interests of all parties, we shall also give further directions on the way forward. Consequently, the following orders do hereby issue. 1. The applications for recusals are hereby disallowed.
On Thursday, Gachagua's lawyers experienced dissatisfaction with the 3 judges, asserting that Justice Mrima is a close friend of Cabinet Secretary Kithure Kindiki, while Justice Frida Mugambi was a student of Kindiki during her master's degree at Moi University. Lawyer Kamwina insisted that these judges are not the only ones in the country and requested the appointment of a different panel of judges to hear the case.
Why should we be the first one within such a short time to be impeached in the country? Is country suspect there is something wrong, that you are not doing something properly? That America, which has had impeachment provisions for 200 years, has never successfully convicted someone from impeachment as for a position.
Thank you, Dr. Kabino.
Meanwhile, lawyer Ndengwa Njiru represented Gachagua's interest, claimed that among the issues discussed during the removal from office were allegations that the former deputy president said that Kenya is a country for shareholders.
Of recusal, and I'll be making reference to 3 materials. I believe they've been circulated. That's a recent Supreme Court decision delivered on 11th of October 2024.
Currently, the case is ongoing as Kenyans eagerly await the outcome of the proceedings.
2002, and we accordingly invoked
Dana Nashipai, KUTV.